I think we can get started. Will the testimony be in the order in the agenda, or will it be different?
I haven't seen the agenda.
Oh, it's Brian, Stephanie, and Larry, or whatever order you prefer is fine.
I'm going to just frame it, then
Yep.
Stephanie, and then Brian.
Thank you.
Okay, thank you for inviting us. My name is Larry Wood. I serve as a Director of Organizing at the Goddard Riverside Law Project, formerly the SRO Law Project. And do want to thank and give condolences to all the new members. It's a tough job you have. You'll be booed and vilified by a lot of those public members, but hang in there. It's an interesting process. There's two packets I gave out. So there's the deluxe one for the new members, and we'd like to request a meeting with you to specifically talk to you about SRO issues and give you more background about the history and about, a lot about SROs that we won't have time to cover today. And then there's the testimony we'll actually be giving today. And I guess we'll follow up with Alex since he's not here. We'd love to meet with him as well.
Larry, before you go on, I have a copy that says LW copy notes.
That's what I was wondering where that went.
I use my skills introduction at LW Larry Wood.
Thank you, Andrew. Okay, so just a quick overview in terms of the numbers of SROs out there, because they are diminishing and have diminished greatly over time. In 1971, there was one study showed there was 165,000 units at that point, and it was seen as substandard housing, and unfortunately some of the tenants were seen as substandard as well, and these buildings weren't often welcomed in neighborhoods, but they were a very vital low-income housing resource. But the city encouraged the demolition and conversion of SROs through J51 and many other programs, and a lot of landlords took advantage of that back in the 70s and 80s. There were a lot of landlords that went to jail over crimes involved with emptying the buildings. The Podolskis have been getting some headlines lately, but our office was responsible for getting them, their dad and them sentenced for crimes involved with emptying SROs. 15 years later, I guess in the early 80s, the city realized we had to do something about maybe preserving this stock as homelessness grew and that stock was disappearing. So in 1986, there was a one-year moratorium on the demolition and conversion of SROs. It was a Blackburn report, and they documented 65,000 left. So over that 15-year period, 100,000 SROs were lost. Sometimes I get rocket scientists to figure out why homelessness grew, and people who had been formerly institutionalized and were living in SROs ended up living on the Broadway Mall, etc. So the city came full circle in a sense, and it led to the birth of the supporting housing movement and preserving SROs by nonprofits. The estimates, David, I showed him reports last year, there's more illegal SROs left in the city, the so-called three-quarter houses and basement apartments throughout Queens than there are legal SROs. So it's still a very needed form of housing, and there's been different studies looking at allowing for new creation of micro units, etc. So the packet I gave you, just I'm going to go through it real quick. The important things to know about SROs, which would come out in the testimony provided by my colleagues. The first page is a notice of rights and duties of hotel owners and tenants. So if you're looking at first page, this is a notice that SRO owners are supposed to give out to tenants who move into SROs. And the important thing to know is that SRO tenants don't have leases like apartment tenants. They're considered statutory tenants, protected by statute. And if you occupy a unit in an SRO, you can be considered a transient tenant or a permanent tenant. And that's an important distinction, because that transiency loophole, as we called it, allows owners to rent out the units for non-stabilized purposes, and that's where huge profits are generated. And it's legal. We've lobbied to try to close this loophole. We consider a loophole, but it's been a feature of the law from the beginning, and it's led to the loss of a lot of this housing. And you become a permanent tenant by virtue of staying there for longer than 6 months. You automatically become a permanent tenant under the law. Or you can do what's called a lease request to trigger your rights to become a permanent tenant. It's a little confusing because you don't get a lease and it's not a request. It's actually a trigger of stabilization rights after you move in. So that's the DHCR notice. The next page is the explanatory statement for the hotel orders. This is from last year. I just copied 2 pages real quick. Thing I want you to note is where it says special note. This is from your prior rent guideline boards have pass this down to newer boards. And there's been these things called provisos, or certain rules that our owner would have to abide by before they could qualify for the rent increase. Initially, it was around warehousing. The argument was, if 40% of the building is empty, why are you crying poverty and you can't afford the building? Rent up the empty units first, and then you could qualify for a rent increase. The additional provisos were developed over the years, but if a significant percent of the building is not being used for rent-stabilized purposes, and the landlord's generating significant income, then they don't qualify for the RGB adjustment. So that's an important thing to acknowledge. We've had 0 for a number of years, which are justified, and that's what we're calling for again. But in the years that there were an increase or an adjustment, the proviso distinguished. It was a way to get around a one-size-fits-all rent increase and to make a distinction between a fully occupied, stabilized building and a building that was generating significant income from non-stabilized rentals. The next page, also from your the explanatory statement, is on the definitions. You'll see there are 5 different categories of SROs. It's always been interesting to me they don't make this distinction among apartment buildings because there's such a range as well. But you have residential Class A hotels, like my friend AC lives in. They're all self-contained units where people have their own bathroom and kitchen. You have rooming houses, which are typically less than 30 units. Many of them could be small, 6, 8, 1 or 2 family homes that were converted into rooming houses. You have single-room occupancy Class A dwellings that are whole or part used at SRO. They're called Section 248 buildings under the multiple dwelling law, a Class B hotel, and then lodging houses, which is really the more austere form of an SRO, where people are living in cubicles with chicken wire ceilings. Not many left, and Brian will be talking about them because they used to exist in greater numbers on the Lower East Side and along the Bowery, but there's still a handful around the city. So there are these 5 different categories. The next page is a chart of the rent guideline board orders historically from 71 to 2009. So you do note a lot of zeros, and that's, again, we've been able to justify that, and that's what we're calling for again. In the years that there was an adjustment, you'll see some notes there about the proviso. So there's different language that's been used over time, but that's the provisos that your prior boards have asked you to retain. So, as I mentioned, the alternate uses of the SROs, colleges, net lease SROs, SROs are, in a sense, dormitories in many ways, and college students coming to New York, it's a big obstacle. The cost of housing in New York could be a big deterrent for many students, so colleges have turned to SROs. Columbia University Teachers College used to have Townhouse 44, the Greystone. In this packet, if you flip through, I have examples from AMDA, the American Music Drama Academy, and I just downloaded some pictures from their websites. They have a couple of SROs. One on the Amsterdam residence is actually right next door to me. I live in 211 West 85th Street, and that's at 207. And it's only a handful of long-term tenants in it, and the rest of them, I see all these drama and dance students coming and going every time a new semester comes and goes. So these owners are making significant money just renting it out and net leasing the building to a college. Beyond the college rentals, we have the tourist and the illegal rental of units for shorter than 30 days. Many of these SROs you're not supposed to rent on a daily basis, but landlords, some have been defiant of that. We've been battling for years for the Imperial Court, a big SRO on 79th Street. I know this is a prior example, but we have new board members, so it's new to you. This particular owner is warehousing. If you go to their website, it says closed, but there's still 60-odd tenants in there, I believe the number is. And he makes a point in this article. It says, tenant advocates would like us to rent these units, and he says they're never going to see another rent-stabilized person in this property again. He says, just quoting here, we're billionaires and we could afford to keep this building empty for the rest of my grandchildren's life, and it will not affect our financial lifestyle one bit. So we're litigating with this person, this owner. They claim that because they had been doing illegal rentals for years, they should be grandfathered in and should be able to continue allowed to do daily rentals. The next example here is just 2 rooming houses, which are really profitable, and that's because SROs on a square foot basis are also very profitable, a lot cheaper to operate. On a square foot basis, you'd have up to 6 people sharing a bathroom rather than having 6 different bathrooms. And if you think of, when we get into the average rents of $1,000 or more per unit, if you're getting $1,000 from 3 different rooms rather than $1,200 from a 3-room apartment, you can see why it's very profitable, both to operate and in terms of the income. And if you look at these 2 examples, it's just incredible, the operating costs versus the income that are generated in these 2 particular buildings. The one up on 75th Street, they advertise can be delivered vacant, which is a little alarming when I talked to the remaining SRO tenant in there who works at a local senior center. I pointed this out to him, and he said, "What do they mean, delivered vacant? I live here." I said, "Yeah, if anything happens, you should definitely talk to us." And I just want to close with the board. There's very limited data on SROs, and Andrew and the board staff members have done a series of memos over the year to try to determine how many SROs would not be eligible for a rent increase because of the provisos, and just how many are left, et cetera. So I gave you this handout, just this 2-pager. And you could see the first page here I just took from last year's explanatory statement, and this is data from DHCR. And you can see the precipitous decrease in the units that are registered from 2009, 22,000, and it just dropping to 17 to 18 to 13 to 11,000. These are units registered with DHCR. There is actually many more out there because there's an under-reporting. And the next document there, the legal size page, the Housing and Vacancy Survey stopped collecting data on SROs because the sample size just got too small. So I copied from 96 and 2002, the last set of data, and then based on the memos, I've tried to extract numbers of units left, how many are vacant, how many are claimed to be exempt from stabilization, so you could see the numbers there and the mean and median rents, which are pretty quite high. And the last 2 memos that were produced, Andrew just sent me them 2 days ago, so I wasn't able to put them into the chart, but it's in your packet. It's the memo from May 31st, 2018 and April 22nd, 2019. And they did a lot of massaging to extract some useful information from this data, and I really want to commend them, particularly Andrew, for doing this. The quick highlight, if you look on the second page under rooming houses, the last sentence there says, of the 148 buildings identified in this analysis, 15% consist entirely of exempt or vacant units. Then it says, in addition, 75 of these 148 buildings contain less than 85% permanently stabilized units. So basically, 96 out of 148 buildings, which represented about 46% of the units, had less than 85% rent stabilized. So roughly half the rooming houses wouldn't qualify for an increase based on these numbers. To the degree we have faith that they're accurate, and I think that's about the best data we have. And
Sorry, Larry, can I just ask you on that point? So last year, for the first time in a while, an owner representative came and made the argument that why shouldn't owners, if they are 85% rent stabilized or more, why shouldn't they be entitled to a comparable increase to what we're giving to apartments? What's your response to that?
It's difficult to challenge these. Tenants have to know what the rules are, and then there's a whole enforcement process. It takes a long time with DHCR. So if we've made the argument, if you are going to go with a one-size-fits-all rent increase, we didn't have the distinction between rooming houses and the bigger units, but it was clear the vast majority of buildings and units wouldn't qualify, so that's why you've done 0 for many years.
But if we had a proviso that said rent increase only for those with 85% or more occupancy as regulated units. What would be the argument against that?
You could do that. Again, it's the only argument we had was just a difficulty with enforcement. If a landlord was going to take the increase anyway, and you'll see that the medium rents have gone up year after year after year, despite years of zero. So unfortunately, a lot of these buildings operate outside the regulatory system
So
anyway.
who monitors that? In other words,
Well,
DSCR?
it's a complaint-driven system, so unless the tenant knows that the Rent Guidelines Board has a proviso which will preclude their owner from taking the increase, and then counting the units, how do we know how many are registered, how many are vacant? It's been a difficult enforcement piece, so that's why we've argued that the zero was made sense. Especially since the rooming houses is a smaller portion of the overall SRO stock. And just
I
to...
had one point
Please.
on that as well. I mean, part of, obviously, the board's function is to weigh out the competing interests of landlords and tenants, and one of the unique features of the SRO market as compared to any other housing market is just the extreme poverty of the tenants. The vast majority of tenants live on Social Security income, which is roughly $800 a month, or excuse me, a large portion rely on that. The vast majority rely on that or Social Security disability income, which might be a little bit higher, but you're still not talking about more than $1,500, $1,600 a month. Even a small increase to someone operating on that monthly budget within New York City can be an absolute disaster. And I'll talk a little bit more about that in my portion of the testimony, but I think it directly goes to that question of, as you're weighing out those interests, the reality is that the SRO owners cannot show that their side of the scale outweighs the catastrophic financial consequences for SRO tenants of even a small increase.
And it's a huge lift for our office to go out and try to educate and organize and get tenants to file complaints, because unless they file a complaint with DHCR, it's, as you know, it's a complaint-driven system. There's no investigation. They can register whatever they want, and the rent could double, and there could be no justification, but DHCR is not going to do anything unless an actual complaint is filed. So I just want
I'm sorry, I just have a question. So are you saying that we should not grant an increase for owners that would, say, have 85% occupied because it would be difficult for you to go around and help people file complaints?
That's part of the rationale. And also the tenants, it's difficult. It's difficult for them, and if I go on to the hotel part, there's practically no hotel that would pass the proviso. We're talking about well over 90%. So if you want to get an increase and then a proviso to protect 5% of the landlords, and then we have to run around for the other 90% and trying to educate the tenants in the building, it doesn't make sense from my point of view, honestly. Let me finish my data, and then I certainly want to answer the questions. I understand. So just on the next page where it says hotels, again on the bottom there of the first paragraph, of the 74 buildings that data could be obtained for, it was close to 5,500 units of stabilized housing. Of those 74 buildings, 10 or 13% were entirely exempt or had vacant units. 42 buildings, another 57%, would contain less than 85% permanently stabilized units. So from these 52 buildings, 72% of the units wouldn't qualify for the increase. But if you flip to the next page, what the board, what Andrew did was look to see the underreporting of the units registered with the HCR by looking at Department of Finance data. And he said, looking at that same stock of buildings, it was estimated to really 16,000 units. And the last sentence there, 69%, 93% of the total buildings contain less than 85% permanent stabilized units. So this underreporting, we're only reporting 6,000 when there's really, over 15,000 units in these buildings. There's an underreporting of the units, so we think many more rooming houses as well as hotels, clearly based on this, would not qualify. So when the vast majority of buildings would not legally qualify, I think it's fair for the zero, and that's what prior boards had determined and why they voted accordingly. So That's the data, and I won't go through it, the 2019, it's very similar. The mean and medium rents are really quite high for these buildings, and that's again why we're calling for a zero guideline. I want to turn it over to Stephanie, because she has to run back up and represent people at our intake soon.
Thank you.
Good afternoon, members of the board. My
afternoon.
name is
The
Stephanie
mic up
Storke.
closer. No, just pull it closer.
Thank you. My name is Stephanie Storke, and I'm a staff attorney with the Goddard Riverside Law Project. The Law Project has provided free legal representation and organizing to support to tenants living on the west side of Manhattan in single-room occupancy units for over 30 years. It is a great honor to have the opportunity to address you this afternoon concerning issues affecting tenants in SROs and Class A residential hotels. We again celebrate the board's vote last year in favor of a 0% rent increase for SROs. This was a fair decision that took into account the need to maintain rents affordable for low-income New Yorkers without compromising the ability of building owners to profit from their investments. The conditions that warranted last year's 0% vote remain essentially unchanged. SRO tenants continue to struggle to afford rent, while buildings designated for residential use by rent-stabilized tenants are increasingly used for other purposes, which generate significant profits in these buildings. We again hope our testimony today will convince the board to vote for a 0% rent increase for tenants of SROs again this year. The picture painted in the 2018 Income and Affordability Study is alarming for low-income New Yorkers. The study shows a consistent troubling pattern of low-income New Yorkers getting left behind while the city grows. New York City's income disparity ratio ranks near the highest nationwide, with the top quintile in average household income making a whopping 28.61 times more than the lowest quintile, an increase from 27.49 in 2016. For the 9th consecutive year, New York City employment levels have risen, albeit slowly. Meanwhile, New York City homelessness levels have risen for the 10th consecutive year. Each night in 2018, over 60,000 persons stayed in the New York City Department of Homeless Services shelters. That is an increase of 562 persons from 2017. For these people, SRO housing is critical. SROs are housing of last resort for the most vulnerable low-income individuals. Thousands of hardworking people, as well as a disproportionate number of elderly and disabled people, call an SRO their home. If the economic situation is difficult for low-income New Yorkers, it is dire for most residents of SROs. Many rely on SSI, disability pensions, SNAP benefits, and similar resources as their sole source of income. Tenants reportedly report incomes lower than $10,000 per year. For an individual with an income of $10,000 who is already paying 50% of their household's income in gross rent, an increase of just 2% in income could easily cause substantial financial distress that would put even more New Yorkers in jeopardy of becoming homeless. On average, housing in New York City is not affordable. The United States Housing and Urban Development benchmark for housing affordability is a 30% rent-to-income ratio. The median gross rent-to-income ratio for all tenants, based on the 2017 Housing and Vacancy Survey, is 33.7%. That ratio has remained virtually unchanged since 2011. The ratio for rent-stabilized tenants is even higher at 36%. Even more disconcerting, a third of rental households pay more than 50% of their household income in gross rent. We observe this reality with the SRO tenants that our organization serves, who frequently pay a substantial portion of their modest incomes, whether from employment or government benefits like SSI and HRA shelter allowance on rent. The housing crisis is not only rooted in affordability, but also availability. The 2017 Housing and Vacancy Survey found that citywide vacancy rate was just 3.63% in 2017. This vacancy rate is critically low, but the situation is far graver for low-income New Yorkers, as vacancy varies widely among different monthly asking rent levels. The vacancy rate for apartments going for $2,500 or more per month was assessed at 8.74%, while the vacancy rate in apartments costing below $800 was a critical 1.15% in 2017. Widespread practices of SRO building owners, discussed further, will seem even more egregious through this lens. New York City cannot afford to increase rents on what is one of the last sources of truly affordable housing for low-income New Yorkers. The low vacancy rates in New York City suggest that building owners have little trouble renting out their units to permanent tenants. SRO landlords, however, have turned to using their properties in ways that allow them to reap higher profits while depleting the availability of this precious affordable housing stock. These uses include renting to tourists, legally and illegally, net leasing to New York City colleges, and entering into lucrative contracts with the Human Resources Administrations and the Department of Homeless Services. A report released in 2010 by the Manhattan Borough President's Office showed 1,336 SRO units were lost between 1996 and 2010 in Community District 7 on the Upper West Side alone. SRO owners are making profits by both legally and illegally renting out rent-stabilized units to tourists on a nightly or weekly basis, depending on the classification, zoning, and fire code regulations that apply to the building. Some SRO hotels are lawfully permitted to offer transient rentals. However, even when renting legally, the vast majority never inform their guests that the rooms are subject to rent stabilization, or that the guest has a right to become a permanent tenant. Although the strengthening of the law prohibiting illegal hotels in 2010 and increased enforcement have helped curb the practice of transient rentals to a certain extent, many SROs owners continue to blatantly flout the law, charging exorbitant rates for rooms whose legal rents would be affordable for low-income New Yorkers. For example, the Broadway Hotel and Hostel, a residential SRO building located at 230 West 101st Street, lists daily rooms for rooms on its website that correlate to monthly rents of over $5,000. Just yesterday, one of the rates listed was based on an $188 per night figure. Another infamous illustration of illegal predatory behavior by SRO building owners can be found at the Imperial Court, as my colleague mentioned, located on West 79th Street. The property is zoned for rent-regulated long-term tenants. The owner, Michael Edelstein, was quoted in Manhattan Express as saying, "We're billionaires, and we can afford to keep this building empty for the rest of my grandchildren's life, and it will not affect our financial lifestyle one bit." He continued, "Nobody can force me to rent these rooms. They're going to be left vacant. Nobody is going to have the benefit of low rents in that building ever again." SRO owners also use websites like Airbnb to rent stabilized rooms to unsuspecting tourists. The Imperial Court, for example, listed illegal short-term rentals on Airbnb. The illegal renting of affordable units through Airbnb has become such a significant problem that in 2014, Attorney General Eric Schneiderman issued a report finding that 72% of all Airbnb rentals in the city are illegal, and that commercial users control a disproportionate share of rentals. 6% of hosts supply 36% of units and earn 37% of the revenue. While this report does not reflect solely on SROs, it also includes data on apartment rentals. It is still compelling evidence that owners stand to profit by renting to short-term transient guests rather than permanent tenants. A more recent report found that if so-called impact listings, commercial short-term listings for an entire unit or home, were added to the residential rental market as vacant units, the number of vacant rental units in New York City would increase by 10%. The report found that commercial use of the Airbnb platform has had a particularly strong impact on already vulnerable populations, such as low-income communities and communities of color. In addition to profiting off of illegal short-term rentals, SRO owners are also keep affordable units off the market by a practice called warehousing, as my colleague had elaborated upon, keeping whole or substantial parts of their buildings empty. As tenants are harassed, evicted, or die, their units are removed from the market. Owners refuse to rent to new tenants, and units lie vacant for years. The purposes for this vary. Sometimes owners keep units vacant for years in order to deregulate them. Some owners keep buildings vacant so that they can more easily obtain certificates of no harassment to convert the buildings for other uses. According to his own words, owner Michael Edelstein of the Imperial Court is warehousing as many regulated units as possible in the massive 227-room building purely out of spite. Other purposes are less clear, but the effect is a drastic and harmful reduction of affordable SRO units for rent in the city. What we do know with certainty is that owners routinely and deliberately choose not to maximize their rental income by keeping highly sought-after units vacant in a city with staggeringly low vacancy rate. The effects of this widespread practice are also known: an exacerbated housing affordability crisis for those already suffering most. To give an example of how widespread the problem is, in the Lost Project's catchment area alone, for the last year, we've been aware of several buildings with large numbers of vacant units. Some of the most egregious examples have included 719 St. Nicholas Avenue, where only 2 tenants were remaining in a 13-unit building, both of whom the landlord was attempting to evict. In the aforementioned Imperial Court at 307 West 79th Street, approximately 63 permanent tenants were housed in a building with 227 SRO units. At the Alexander at 306 West 94th Street, 4 permanent tenants were housed in a building with 114 SRO units. And perhaps most egregiously, the Camden Hotel at 206 West 95th Street had just 1 permanent tenant left in a building with 207 SRO units. Since the owners of these and other buildings with warehouse units are foregoing rents from permanent tenants, they certainly do not deserve any rent increases from this board. Conversely, tenants in these buildings are frequently harassed and struggle on limited incomes to diligently pay their rents. Any increase would bring potentially catastrophic consequences for these vulnerable New Yorkers while rewarding their landlords' unscrupulous and often illegal behavior. Rent increases for tenants cannot be justified in SRO buildings that are not fully occupied by permanent rent-stabilized tenants, or where the building's income is dependent primarily on sources other than its rent rolls. Many SRO buildings earn the vast majority of their income from sources other than renting to permanent rent-stabilized tenants. Rental income from permanent tenants is often dwarfed by the staggering profits these landlords make from illegally operating tourist hotels, student dormitories, and lucrative contracts with city agencies. In instances where there are no such operations, rental income could be increased simply by returning the warehoused vacant units to market. Additionally, no proviso should be passed, such as the one prior to 2012, that permitted rental increases in buildings that had a certain percentage of occupancy. Such a proviso would not be warranted in the current context. Percentage of occupancy is not the only metric by which to measure whether or not rent increases are warranted. Warehousing is only one of many common practices affecting SRO buildings that should preclude rent increases. More broadly, as discussed previously, the housing crisis continues to disproportionately affect low-income New Yorkers, for whom even small increases in rent can be unmanageable. Provisos also cause additional problems. Based on our office's experience, tenants have frequently been forced to bring complaints with the New York State Homes and Community Renewal to challenge landlords' illegal increases under past provisos. Our office in particular has challenged numerous illegal rent increases in years when provisos have been in effect. In the past years, with the 0% rent increases and no provisos, the number of illegal overcharge complaints our office has had to file on behalf of SRO tenants has decreased dramatically. The risk is too high that tenants would face similar illegal increases if a proviso were passed, and it is likely that many tenants will simply pay the increases or be evicted without challenging them. And because of the widespread practice of warehousing and the alternative uses property owners make of their buildings, the majority of SRO buildings would not meet the proviso criteria to qualify for a rent increase. Therefore, we encourage you again to vote for a 0% increase for SROs and hotels without any proviso. For all the reasons presented, we do not believe that owners of SRO buildings should be rewarded with a rent increase this year, and we urge you to vote for a 0% rent increase with no proviso. And I again want to apologize that I have to run. Thursdays are our intake days from 4 to 6, and we're one attorney short today, so I need to be there. But thank you so much for your time.
My name is Brian Sullivan. I'm a staff attorney at Mobilization for Justice. And I'm just going to make 5 basic points as to why a 0% increase is appropriate again this year. First one, I was sort of lamenting and joking with Larry the other day that we're kind of telling you the same thing over and over each year, and especially for those of you who are coming back. I was sort of joking, this might be getting a little boring for you guys, but the fact is, the basic situation that warranted a 0% increase for the past several years has not changed. Everything that caused this body to give a 0% increase for SROs is the same, if not worse, for tenants, because the city continues to become more expensive and SRO tenant incomes simply don't keep up. So that basic situation remains the same. You can look at...
Brian, just on that point, so what kind of cost of living increases on Social Security and SSD have there been for the last few years?
I should have that figure just on hand. I don't. I know, I'll give you a sort of a gap, rough estimate, I guess. Going back, I think 6 years, SSI, I believe, was $735 a month, and I believe that's up to $820. So roughly $100 per month over about a 6 or 7 year period. We could get you more specific data on that, but it's very small. With Social Security disability, it's similarly very small. With public assistance, things like shelter allowance, food stamp, shelter allowance hasn't changed at all. Food stamps are, I believe, about the same as well, maybe very slightly higher. So that basic economics have not changed. 2, as I had mentioned earlier in trying to respond to the question you had raised, SRO tenants are the poorest tenants in the city, perhaps with the exception of people living in homeless shelters, and that's where SRO tenants are going if they face a rent increase. SRO housing has been the housing of last resort in New York City for many, many years, and that continues to be the case. SRO tenants are older, disproportionately disabled as compared to other tenants in the city, and just face very extreme poverty, some of the worst poverty our country has to offer. And a small increase in the rent can be devastating. Offices like the Goddard Riverside Law Project or Mobilization for Justice can mount very clever legal defenses when an owner tries to bring a meritless case of some sort. So if they say you're not a tenant, you're a licensee, this isn't an SRO, we're going to evict the whole building. We can mount clever legal defenses to that. We cannot defend against a legal increase in rent. It's not possible. If the rent is in fact increased pursuant to an RGB order, then we can't stop the eviction at that point, and it's going to contribute to the city's already very severe homelessness problem. I think it's also sometimes helpful, especially for newer members, to talk about, and this is my third point, the sort of physical layout, what we're talking about when we're talking about an SRO. As Larry had said, there's sort of a variety of units. There's ones in large hotel type buildings. There's ones that, if you look from the outside, it would look like a brownstone. And then on the Bowery, or sort of, I guess, the most dramatic looking ones, it'll be a large loft space separated with rooms separated by plywood or thin wood with chicken wire ceilings. All of these, in any of these situations, you're talking about a small room. In perhaps the sort of rooming house in the brownstone might be the biggest, but even then, you're talking about what would be one room, a small bedroom or something like that, and that's it. In a Bowery-style cubicle, you can stand and, I'm a small person, I can almost touch each wall reaching out like this. They are tiny, tiny units. And that means that the landlords who do fully rent those out are securing a high amount of rent per square foot. Even though the rents are low for each individual unit, they are given the amount of units that are crammed into a space, actually high per square foot land rent. So we're talking about increasing units for very low income people on very, very small units. Point 4 is, and this is one of the things that actually I would like to get you some better data on next year. We'll see if we can put something together, but I think the illegal market, which Larry had also talked about, is a very interesting comparison. Our experience in the illegal market is that the rent per per room in the, sometimes it's called the de facto stabilized market, is quite low. Almost, I've never seen a de facto stabilized unit or an illegal market unit with rent more than $1,000 a room, which is I guess roughly the average for the regulated market. They tend to be much closer to $200 a room, $400 a room, something like that. That means that there is a profitable way to operate an SRO-style operation at rents far lower than are authorized within the regulated market. It's hard to come by exact figures. We're going to try and put together data based on our, cases, tenants we represented in these types of units. The market is illegal, so sort of almost by definition, it's hard to collect very good data on it. But our sort of not entirely scientific finding is that the rents in this section of the market are much, much lower than any other part of the market, and that it is obviously profitable to operate that way. The final point I'll make, again, echoing some of my fellow panelists this afternoon, is owners find other profitable strategies for operating these buildings. I mean, it is telling that in the past, 7 years, 10 years, SRO owners have only come to testify once. They're not clamoring hard for an increase here because they've got other ways to make money on these buildings. And the reality is there's no increase that this board can give that would sort of change those economics. If the board gave a 700% increase or something like this, it would still be more profitable for the owners to rent to DHS and other city agencies, to run illegal hotels, to run three-quarter houses, also illegally. Any number of strategies like that are still going to be more profitable. And so when weighing out the relative costs and benefits for tenants versus owners, it's clear that owners cannot demonstrate that a rent increase is going to be the key that changes the sort of dynamics or the economics of operating these buildings. Larry had also talked about the sort of question of enforcement and enforcing SRO tenants' rights within these buildings. It is challenging in SRO units. Like I'd said, you have a larger proportion of elderly and disabled tenants for whom it is difficult to bring say a rent overcharge action or something like that. And it's given that the owners are primarily trying to evict people to convert the unit to other use, enforcement becomes particularly difficult and important in this section of the market where there's so much pressure on the tenants. So for those reasons, we ask that the board once again issue a 0% rent increase for SROs this year.
Okay, I have a question.
Of course.
I get the owners that are illegally renting their spaces out. I understand that. I've been doing this a very long time, just so you know. SRO tenants are amongst the best represented tenants in the city, okay? There's West Side SRO. I mean, every SRO tenant can get free representation. They are all well represented if they need it. Absolutely true.
There's a limit on the case. I beg to differ. Right to counsel's being implemented, but we don't take every single case that comes in. Not everybody has a
I'm
lawyer.
not the only game in town, okay?
Okay.
But I'm not talking about the owners that are trying to evict tenants or the owners that are, using Airbnb or the owners that are doing a lot of other things that they shouldn't be doing.
Right.
I'm talking about a hotel owner that's operating 85% full and is doing what they're supposed to be doing. Why aren't those people entitled to an increase?
They can come down here and ask for one, but they haven't for many years.
So, and not every owner in the city comes down and asks for an increase. Just because you think that they shouldn't get one, why shouldn't they get one if
Sure.
they're entitled to it? That's what I'm asking.
Sure. In order for you to accommodate the absolute minority of tenants that might apply, of landlords or owners that it might apply to,
Even if it's a minority, let's say it's only 10%, but if 10% of owners are doing the right thing, what they're supposed to do, they're running their building legally, their gas and their heating and their fuel and their insurance, everything else is going up, okay? Like every other owner. So I understand about the other people you're talking about,
Sure.
but why shouldn't the good guys in the industry, why aren't they entitled to an increase?
I just don't think there's many, for one. And,
There's one.
and
Okay,
the,
let's
the
say there's
bad,
one.
the bad act, it's a fallacy to think everybody has a right to a lawyer and exercises that. I've talked to many seniors who don't take scree because they think it's some sort of handout,
That's free and trade.
No,
Why aren't they getting it?
many seniors who qualify are not signed up. And I've talked to many tenants about challenging a rent increase, and they're scared of their landlord, and they don't want to confront them. You have people who may not be documented and afraid of filing papers. There's lots of reasons why enforcement is difficult. And our office, it's triage in terms of making decisions about who you can represent and who you can't represent, and who you give a packet to and say, here's what you go do on your own. Because there's a limit. We have 6 organizers. You're talking about thousands of units. And I've gone out and leafleted, and I've done a lot of outreach. It's a fallacy to say that everybody has a free lawyer and is well represented. That's not the case for poor people in the city.
But it doesn't make any sense to say if there's 100 bad guys, and there are, okay? I'm not saying there aren't. There's 100 bad owners trying to get people out because they want to make more money on their building. But there's 25 guys that are running their building properly and are, pay for maintenance of the building, provide services to their tenants, give them heat, give them hot water, give them everything they're supposed to give them. I'm just not understanding. I get the rest of what you're saying, but why aren't those 25 owners entitled to an increase?
I think part of the problem would be, how do we administer that exactly? If you were to give an across-the-board increase, or even an increase with the proviso, even with the proviso, whatever it is, the 100 to 25 would be a very generous interpretation of the ratio. It's far, far fewer SRO owners who are fitting the criteria you're laying out. That would then give license to this huge number of SRO owners who are not operating in that way. It would give them another tool to harass an already over-harassed section of the population.
Yeah.
And so the best remedy there would be for the 1 or 2 owners who are trying to do their best, these 1 or 2 hypothetical owners, to convince their countless other colleagues to run things above board, because as it stands now,
The right thing to do the right thing.
perhaps not, but this, if the board were to authorize this increase, it would give a tool to all of those other owners that is unwarranted. So in doing the sort of difficult weighing that this board has to do, and just to, sorry, one other factor that should be in that weighing, and I'm sorry to repeat myself here, is that even for those owners, even for the good owners, they are going to have exceedingly poor tenants, and they're going to have tenants who cannot afford an increase. And so when doing the sort of difficult weighing that this body has to do, that 1 or 2 hypothetical good owners just can't outweigh everything sitting on the other side of the scale, the extreme hardship, the majority of owners who aren't operating that way.
Those tenants are entitled to the scree and the dree, and they're not taking advantage of it, so why should the good owners be punished because the tenants won't take advantage of what they're entitled to?
I think that the last 2 memos that the board produced shows, if you look at the charts on the medium rents, collectible and preferential, there's a lot of preferential rents in SROs as well, which would mean that the legal registered rents are higher than what the market would bear.
That just means there was turnover in the room. There was a lot of turnover.
Could be turnover. I don't know if that's what it's showing necessarily, but if they're not collecting the full legal registered rent, why would we do an increase anyway? The off-market, the illegal SROs, if those rents are less than legal registered rents and they're profitable, these buildings are still highly profitable. Owning the SRO is a very profitable proposition in the city, and I don't think the increase is warranted, period.
That's a separate argument to say the increase is not warranted. I'd rather, to be honest with you, go back a ways, I'd rather have that discussion of whether or not an increase is warranted than to say to somebody, I'm just thinking of the one person in jail who says, I'm innocent. Right? I'm innocent. Why am I in jail? And I understand.
That's a good point.
I'm innocent. You can't put me in jail. If I'm entitled to it, I have a hard time,
I agree.
And all of this stuff. but I'd rather explore the fact whether something is not warranted, because I can hear the whole fact that if I had my investment in one, the city was, because it made sense, it might make sense. That's a more reasonable argument to say, hey, this, you know, and given all the other mess, it's not even needed, then why mess with it? Than to say, I'm entitled to it, but you're not gonna get it because everybody else is not.
No, that's a good point. And additionally, I mean, if, as you know, if there is a real hardship and an owner is not making a significant return or a return on their building, there is provisions to apply for a hardship increase. Very few owners apply. I don't recall, and that's what happens with enforcement for tenants as well. But my point is, I don't know if an SRO owner has ever done that. I don't, if there are any owners, if you find any SRO operators who can make the argument, I'm not breaking even, I'm not making some money in my building, then yes, let's have that discussion, but it just, in my mind, it doesn't exist.
Thank you.
Thank you.
Thank you. And then I guess for the new members, we'll reach out to you about setting up a meeting, and we can go through some of the other material we shared with you earlier. Thank you.
Thank you. Thank
You
you.
have had a full, long day, so
We have, thank you. So,
hang in there.
do I hear a motion to adjourn?
just-
Oh, wait, I'm sorry, one thing from Andrew.
Yeah, so we have dates for the hearings. We haven't released them publicly yet because we were sort of determining a Manhattan hearing spot. We've been going to the Oberia Youth Center, but last year they had no AC, which was tough. So we were trying to find another venue. So our inclination is to hold off a little longer in announcing them publicly till we try to figure that situation rather than release a location and then pull it back. So the dates are the dates. You all have those dates. It's June 11th, June 13th, June 18th, and June 20th. The 20th is the one that we're trying to find the venue.
These are the
So-
hearings for public testimony from
Public
landlords and
testimony
tenants.
hearing. So we should know, hopefully in the next, before the preliminary vote, we can release those. So I just want to let you know that that's our thinking behind it. But anyway,
Is
Are we good?
is the final vote set, too? The final vote?
June 25th.
June 25th.
At Cooper
yes.
Union?
Final vote's June 25th. Yep.
Do I hear a motion to adjourn? A second?
Second.
See you all soon. Thank you for the long day.